Good morning, Your Honors. The matter before the court this morning is the case entitled Iver versus Simpson, case number 24AP183. Representing the appellant, David Simpson, is attorney Charles S. Martin. Representing the appellee, Olya Iver, is Isabel Pickett. Present with Isabel Pickett is attorney Chester Harper and attorney Mary Mason.
All right, very well. Appellant, please introduce yourself and your client, and then you may proceed.
Charles Martin, appellant in this matter.
All right, you're going to need to speak up. We can't hear you.
Charles Martin, I represent the appellant. Is everyone hearing me loud and clear?
Yes, we are now.
Okay, good. Best interest of the child. Best interest of the child is repeated over and over and over again in any dealings in parentage, divorce, any situation where there's a child involved. In a situation where there are two parents, the legislature has made it very, very clear that the best interest of the child under Section 650 is for the child to have the maximum amount of time with both parents. Each parent should have the maximum amount of time. What we have here is a situation where this case provides the opportunity for the child, for the child to have the maximum amount of time with both parents. This case started during the COVID situation, and obviously the COVID situation changed everything, including the time each parent would spend with the child where the parents were no longer together. In this case, at the time, the father was living in New Hampshire. The mother was living in Burlington. Because of the COVID situation and the length of the distance between the parents and the father, specifically the father and the child, the judge issued an order indicating that the father would have time with the child every other weekend. Then after the final order came down, providing for the visitation, the father moved to Burlington. Instead of 93 miles away and an hour and a half away from the child, he is now perhaps at most 9.3 blocks away from the child and has the opportunity to have more time with the child. What the judge below did here was look specifically at the parents and took the position that the distance, that the change in location was an insufficient grounds for a change of all circumstances. In looking at this, it related to the situation for the parents. But what we have here is a child, and what was not considered was the right of the child to have more time with the parent, each parent.
So, Mr. Martin, even if there were a change in circumstance here, what would be a parental plan that would be in the child's best interest, in your opinion?
I mean, the parental plan would be as close to a 50-50 situation with the child. But we're not here to determine what the parenting plan would be. What we're here to determine is whether or not there should be a hearing to make that determination. And what the judge below did was simply cut that off. So there was no opportunity for the parties to indicate what would be the appropriate visitation. And in fact, in this case, there was a bifurcation between the change of circumstances and the question as to what the schedule should be. So we're not
That's
even
not
looking at this.
unusual for a court to bifurcate the change in circumstance.
I'm sorry?
It's not unusual for a trial court to bifurcate whether or not first is a change in circumstance, and second, whether or not, if there is a change in circumstance, what would be in the child's best interest. And that's fairly common for trial courts to do.
All right, Mr. Martin, your time has expired. We'll allow you to respond to Justice Cohen's question and then please wrap it up.
All right, that's fine. The situation that we're dealing with here is there is an immediate issue of the change in location of the parents as to travel time ever since Hawks has announced once there is a change of plans, it may not necessarily be a situation where that opens the door to change of circumstances, but considering Section 650 and the demand that the legislature has to look for the best interest of the child in providing the maximum amount of time, that statute makes it incumbent on the court to take a look at the question of whether or not there should be a hearing to determine a schedule. This is not a case.
We'll have to leave it there.
Thank you, Your Honor.
Thank you, counsel. All right, the Applebee's representative, please introduce yourself and your client, and then you may proceed with your argument.
Good morning, Associate Justices, and may it please the court. My name is Isabella Pickett, and I represent the appellee, Olya Iver. In this case, the appellant argues that the lower court abused its discretion by failing to consider the best interest in the first phase of its bifurcated modification proceeding. But this is not the test, and best interests are already considered and contemplated in the original order. The main question is whether the appellant has met the statutory standard of changed circumstances that warrant revisiting the final order. The lower court here found that the relocation was not real and it was not substantial. It found this because the relocation of the appellants reduced the commute time by 1.5 hours, which the court found insignificant, and the appellant described themselves as an easy commute. The appellant appears to be asking this court to revise the well-settled two-step test for modification by transposing the best interest inquiry into the first prong of the test without clear support or controlling precedent. This test is good law, and the lower court here applied it correctly based on founded considerations, meaning that there was no abuse of discretion and it should be affirmed. As for relocation, the final order contemplates both the appellant's relocation to Vermont, and separately it contemplates COVID-19 ending. Relocation without more is not a per se substantial change in circumstances. It is only substantial when it impairs rather than improves a parent's ability to exercise their rights as established in a final order. In the Hawks case, this was a custodial parent who relocated away from the non-custodial parent, which the court said amounted to a substantial change in circumstances sufficient to warrant looking at the best interests of the child for modification.
So do you think there's any error at all regarding the bifurcation from the first step of the analysis, which is change of circumstances, to the second step of the analysis, which is best interest, for a trial court to make a determination on the first step only?
No, Your Honor. We believe that the bifurcated proceeding actually protects the interests of the child, and by keeping that separate, it helps maintain a clearer distinction. So we do not believe that there was any error in keeping it separate in that way, because absent that, then parties would be able to easily alter final orders and have continuous bites at the apple, and final orders would never be final in the sense that a party could easily manipulate it by just changing or relocating, and then it would it would cause courts to have to revisit these final orders. So in conclusion, the best interests should remain in the second prong of the test as it was properly used here, and as it has been since the statute's enactment, and the lower court should be affirmed because it used the test correctly.
So is it your position that the court shouldn't consider in any respect the best interest at this point in the analysis?
There is, Your Honor, so there is the ability for, when determining whether something is substantial, for the court to consider the impact on the child and the child's best interest in determining whether a relocation is substantial. However, there was no impact on the child here because the only difference was the hour-and-a-half commute, which was on the parent and not the child. So that, yes.
All right. And with that, the bailiff may call the conclusion of the case.
Your Honor, do I have any rebuttal time left?
You have no time remaining.
Thank you, Your Honor.
The next hearing for the court will follow immediately.